Hello guys, and welcome to another episode of my lecture. On today's episode, we will be talking about the second exception to the indoor management rule. And the second exception is transaction of unusual nature or suspicious circumstances. Now, one can't rely on this rule if he refuses to make inquiry which ought to have been revealed to him that such things were wrongly done. I believe you as my students do understand this principle already because I discussed it in the case of Northside Development Property Limited versus Registrar General, where I told you that Dawson J in that case stated that where there are special circumstances sufficient to place a person dealing with the company upon inquiry, then the court will not presume that there has been regularity. So when we are looking through the case of Northside, you would see that the special circumstance there was the fact that one of the directors of Northside went to the bank to get a loan, not for Northside, but for his own personal company. But the land which was the security for the loan was for Northside. The court held in that case that it formed special circumstances, so much so as to put the bank on inquiry. Now, in this case of Underwood versus Liverpool, the fact is that the sole director and the principal shareholder in a company paid check drawn in company's favor into his own account. The judgment of the court is that the bank was put on inquiry for failure to make necessary inquiry. The bank wasn't entitled to rely on the director's ostensible authority. The unusual nature of this transaction was sufficient to put the bank on inquiry. It was thus not entitled to presume that the director had authority to pay the company's check into his own account. This is a very unusual transaction. How would there be checks from a particular company and you did not pay the check into a third party's account or something? You paid it into your own account. Except you have been given authority, the bank should know that something is wrong. Do you understand that? That would form special circumstances, as Dawson J held in the case of Northside Development Property Limited versus Registrar General, that where there are special circumstances, then the third party, in this case the bank, should be put on inquiry. This case being Underwood versus Liverpool. So basically, where employee or agent of the company doesn't occupy position in company which it will be usual for him to delegate authority to bind the company won't be bound unless he has actual or he has been held out to have authority. Held out there being he has been given ostensible authority. Do you understand? So where an agent isn't normally given a particular position in a company. For example, I can be working for First Bank Nigeria Limited, but there are certain transactions that only the managing director can have. And then I went to a bank and then I told them that I want to make those transactions. I do not hold that position. The court would, in that case, if it got to court, hold that I'm not occupying a position where such transaction is possible. Neither do I have ostensible authority, as the bank, in this case First Bank, has not held me out to have such authority. So why would the bank then enter into the transaction? Do you understand? That's what this rule is saying. So we also have the last case of ONUH versus United Nigeria Insurance. In this case, the indoor management rule was held inapplicable as the company was not bound on the basis of letter written by a clerk who did not even sign in a representative capacity. The plaintiff had duty to find out the position of the person who signed on behalf of the company, and he wasn't entitled to assume that the clerk was an authorized official. When you are talking about this rule, you are talking about what happened in Northside case, where somebody decided to take a loan for another company. That's number one. You are talking about case of Underwood and Liverpool, where somebody decided to pay checks belonging to the company into his own account. You are talking about the case that I painted, where I get to a bank or something and I want to do something that only the managing director can do, like the case of ONUH. In that case, the clerk did something that only the managing director can do, and there was nothing to show that the clerk had authority. So that is an unusual nature of a transaction or suspicious circumstances. Therefore, the third party should be put on inquiry. The third party should know that something is wrong, and where such an exception pops up, then the court would not grant a presumption of regularity. So now we are going to the third exception, and that will be discussed in the next class. See you in my next class.